Hi, I want to talk to you today about jury selection, or what more accurately should be called jury deselection. Again, my name is Vlad Genshu, and I am a personal injury litigation and jury trial attorney in California. I've tried most of my jury trials in Los Angeles County. I've done one in Orange County Superior Court. I want to talk to you about what the real goal of jury selection is meant to be. When you think of jury selection in a civil jury trial, you should think of your ultimate goal, which is to deselect, not to select, because you're ultimately never going to get a great jury, but to deselect, to get off the jury all of the horrible people that will not view your case in a good light. Which, the way I see it is, you got to think about what kind of case do you have. If it's a personal injury case, which is the ones I do, which is a car accident case, slip and fall, trip and fall, there are some people who, they're not horrible in the sense that they're bad, but they will make horrible jurors because they have preconceived notions about your case, either about something about it specifically, pain and suffering, whether they can award it or not. They can compensate your client fairly to their damages, whether they like personal injury lawyers or not, whether they don't believe personal injury lawsuits should be out there and be litigated in court. So the way you need to think about this when you are selecting a jury, do not be upset if you do not get your ideal panel, because you can't. You're not going to get your ideal jury panel. Think of, in a way, jury selection as tic-tac-toe, the ultimate tic-tac-toe game, in the sense that nobody can really win at tic-tac-toe. It is impossible. If you're going up against another attorney who is competent, you're not going to get the panel that you absolutely want. But what you want to do is make sure you don't get the worst panel. The worst jurors have to get kicked out, and we'll talk about how to do that. Like I said, anybody who's ever played tic-tac-toe should never win or lose tic-tac-toe, because the other side knows how to play the game. It is ultimately a blocking game, right? Jury selection is a blocking tactic that has to go on. You are going to identify the worst jurors for you, which are always going to be the best jurors for the other side. All right, so in California, the California Code of Civil Procedure 222.5 says that any litigant, a person who goes into court seeking justice, has the right to a fair and impartial jury, which means that they have to be completely, and that is the term, completely impartial. Okay, so you start out with that idea. So how do you determine whether somebody is completely impartial or whether they are biased? And remember, we have implicit biases and we have biases that are more direct. Okay. The first thing you have to do is, if you're trying a case and you've never tried a case, it is very, very difficult to get people to admit in open court before a judge, who's wearing the judge's robe, has been elected, and a judicial officer, a Superior Court judge, in front of the American flag and the flag of the state of California, to say, yes, I'm biased. So you have to really ask yourself, how do you get that without them using the term bias? Because nobody wants to admit one way or the other, and we're trained not to admit that we are biased, because the idea is with bias comes prejudice. And yet, in reality, that is exactly what you need to find out. You need to find out who is so biased, who is so prejudiced to your personal injury case that you do not want them under any circumstances to sit. So, before we redefine the term bias, which is in many ways a four-letter word, like I tell the jury, it is a four-letter word that is bolded, highlighted, and underlined, you need to understand the following concept. It is nearly impossible for the plaintiff's attorney or the defense lawyer to say something, unless it's outrageous, that will make the jury change their mind about how they view the case in jury selection. In other words, you cannot poison the jury well, the jury pool. So don't be afraid of asking a tough question, thinking, oh, I'm going to, make the jury angry, or I'm going to make the jury is now going to see the case in a different way. That's something that trial lawyers who have not tried a lot of cases think about, right? They say, oh, if I say something, that the jury is going to automatically, not like me or not like my case. No, that's something I remember. My best trial advocacy training was with the Los Angeles City Attorney's Office. And I asked that question. I said, is there some kind of question that you can ask where you basically lose the case because the jury just hates you afterwards? And the answer is no. And here's why. No attorney, plaintiff or defense, whatever kind of case, is that persuasive that in jury selection, you're going to change 12 people's minds, or how many people's minds, based upon decades of experience in life. So don't be afraid to ask the tough questions. That having been said, there's certain topics where you have to hit on, okay? And some that you probably don't need to. So let's talk about the idea of bias. How are you going to get the jury to basically say, yes, before I even I hear any evidence, before I hear anything about this case, except the mini opening statement and the joint statement of the case that the judge read, and the mini opening that the attorneys gave, you're done, right? I'm already leaning towards the plaintiff or the defendant, right? So I want to break this down to you. Here's how I define bias to a jury, right? I tell them, Mr. Jones and Miss Jones, and this goes for the entire jury panel. We obviously thank you all for being here. I don't want to get too much into that because you don't get a refund on time. You heard the court say that we have the right to an unbiased jury, right? And there's a reason for that, right? We want to just look at the evidence. When we hear the term bias, we think of a 4-letter word, right? Literally and figuratively, B-I-A-S. It's bold and it's highlighted and it's underlined. And it's really tough for anybody to say bias, right? Or I'm biased. So the way I see it, in a case like this, a car crash case or a slip and fall, trip and fall, personal injury case, the term bias, it's not that kind of bias that we hear about in the year 2023 or, deeply ingrained prejudice. It's not that kind. What it is can you be a fair umpire? Can you be a fair referee? And here's how I see it. It's still something that is very much a part of you and ingrained because you're going to lean one way or the other. So imagine this. When I say, are you biased towards one side? What I'm really saying is, imagine that you are a huge Dodgers fan and you bleed Dodgers blue. That is your team. You love that team since you were a kid. You love baseball, but you love the Dodgers. And imagine yourself now. Imagine yourself being given the opportunity and being the umpire, okay? But you're now the umpire in the World Series. It's Game 7, tied 3-3, and it's the Dodgers. They're up against, who knows, another team, right? But you're a Dodgers fan. Can you be a fair umpire? Can you just call the balls and strikes as they come, right? Whether it's the Dodgers up against the Orioles, the Red Sox, who cares? It's just the Dodgers against the other team. Can you be fair to both sides? Or is your life, that love for the Dodgers, going to come in and you're going to go a little bit and call it a strike and a ball the way you shouldn't? That's the kind of bias we're talking about. That makes it more understandable and relatable, in my opinion, for the jury. And then you go into the topics. Now, the one thing that I did there that you got to limit is, in jury selection, the lawyers should do a minimum amount of talking. You should ask open-ended questions, and you should let the jury talk, and ideally create an ability. It's kind of like a town hall, right? Where you're the person who's just trying to moderate it. You're trying to get the person, if you will, to open up, and then you go to another juror. So you ask an open-ended question, right? And you say, the bias thing. He says, just before we get into anything more, I want to put together the idea of how jury selection works in California State Court. So the state legislature in 2018 allowed litigants to ask parties in a dispute, in a lawsuit basically, to ask for what's known as a mini opening statement, right? So the first thing that happens is, you get the jurors in there, and the judge at some point in time, after really simple jury instructions, starts talking about, reads the joint statement of the case, which is both sides agree to a very bland, boring, simple, vanilla, opening statement. On January 6th, 2019, a car accident occurred at the intersection of, La Brea and whatever in Los Angeles, California. Plaintiff, John Smith, is suing defendant Jane Doe over personal injuries. Jane Doe does not dispute liability in this case, but she disputes whether the medical treatment of John Smith was reasonable and necessary. Right. Basically says this is a personal injury case, started on this day when there's a car accident, this person is suing this person, they don't dispute liability, or they do dispute liability, they're disputing. So that's all the jury first knows. It's a car accident case. So think about, what information did you tell them with that? You either told them it's a car accident case and it's a rear ender, or it's a car accident case and it's a rear ender, or it's not a rear ender and they're disputing who done it, who caused it. Okay. So you already told them this is a PI case. So there's already people thinking, they didn't know what kind of case it was when they walked into the courtroom, right? They thought it might have been a business dispute. They thought it maybe would have been a criminal case, maybe not. Now they know it's a personal injury case, right? So you're dealing with already bias of, do I really want to spend a week of my life, right? You never get a refund on time, on a personal injury case? Or am I thinking to myself, I got to get out of this thing, or maybe I do want to spend time and sit in judgment on that? That's number one. After the joint statement of the case, at some point in time, both attorneys will be given a mini opening statement, which isn't really an opening statement. What it is, if you will, is a preview to jury selection. As a plaintiff's lawyer, I was taught that the best mini opening statement, which should be no more than 2 to 3 minutes, max 4 minutes, depending on how big the case is. I've seen some go for 20 minutes in very complex medical malpractice cases, but for your average, car accident case, you're looking at 3 to 4 minutes, 4 minutes max. You should highlight a little bit about the case and then highlight your problems so that the jury now understands, here are the problems in your case, right? And then that's really what the jury has heard before you do your jury selection. And the defense will also do their mini opening statement. So think about what information you are working with, right? In your mini opening, you might have said, yeah, folks, this is as the court read to you, as the judge read to you, it's a car accident case, car crash. It occurred back in January 3rd, 2019, taking us a little bit of time to get here. We really appreciate you being here. They called a trial because it's tough for both sides. We were clearly rear-ended, but no ambulance arrived at the scene. Nothing occurred until 2 weeks later in terms of medical treatment. That did happen. First treatment was a chiropractor. This person, my client, Ms. Jackson, she'd never been to a chiropractor before. You're going to hear that all the chiropractic treatment, all the medical treatment is on what is known as a lien. It's an IOU where she didn't get, basically she got the medical treatment and she's got to pay it. She owes it, but it's going to be paid only after the case either resolves. And we're here because this is our last chance to resolve the case. There was no emergency room treatment the day of, and we're here now because we need to resolve this case. So you've already signaled to the jury the weaknesses in your case. Why would you do that in mini opening statement? The reason you would do that in mini opening statement is because you want to flag your problems so that the problem jurors come out. You want the problem jurors to begin to emerge, right? With that little bit of information, car accident case, rear ender, no treatment the day of, chiropractic treatment's the first one, and it's on a lien, and the person never saw a chiropractor before, you're already flagging the problems of your case, right? And when you start jury selection, you want to go into those issues with the jury to see if just with that information, you are starting behind so you can get those jurors off for cause. Which brings another issue. When you're doing jury selection, there's two kinds of strikes that you have the right to. One is known as a preemptory strike. You have the right to 6 of them in California. You can strike for any reason, except reasons that are prohibited by law: race, gender, sexual orientation, ethnic group, socioeconomic group. But you're basically almost anything else. A hunch can get rid of somebody else. The way they tied their shoes, I don't know. Those are 6 of them, right? And then you have unlimited for cause challenges, which are really hard to get because basically the idea is the person is so biased, so prejudiced against your client or against your case that the minute they walked in after mini opening statement, the joint statement of the case, having heard no evidence, because you don't hear any evidence in jury selection. The evidence only comes in on the stand, right? The attorneys the attorneys talking is not evidence. It's only what you hear on the stand or documents that you see, or that documents that are received and admitted into evidence. So basically, having only heard a little bit about the case that is not evidence, no testimony by any witnesses, can you get those people off for cause? And it's really hard to, right? But that's what you want to do. You want to flag your problems in your mini opening statement, and then you want to start talking about what are the weaknesses in my case, and then start going through themes. So think about it. You would think that you want to identify your good jurors. No, you want to, if you will, identify your bad jurors, right? The jurors that are, they can't give money for pain and suffering. It's not who they are. They either don't believe in the concept, right? Tough it out. Life's tough. Life's unfair. Or because there is no formula for it, they're not going to give it. One of the things that I would back up and say, even before you talk about specific aspects of bias, you need to remember one big picture. And it doesn't usually happen as much in a car accident case or a trip and fall. It happens more in a medical malpractice case. In those cases, and in general, if you can get this, if you can have a juror say, I don't think this case should be brought to court. And you see that in medical malpractice cases where people don't think doctors should be sued. Medicine is an art and not a science. If you can get them to say, I don't think personal injury cases, I think there's too much ambulance chasing going on, I don't think these cases should be brought before a jury, that's a for cause challenge. You should absolutely stop there and stop asking questions. Because anything you say after that, there's a good chance that you're going to rehabilitate unintentionally that juror. If the person basically says, yeah, you know what, there's too many lawsuits, I don't think these cases, and the judge does his own or her own jury selection, where they will ask that question, does anybody think that these cases should not be brought into court? If you can get yourself to ask that question, you're more likely for the person. It's very hard for somebody to tell a judge, yeah, Judge, I don't think that, Your Honor, this shouldn't be brought here. I mean, basically kind of telling the judge, I don't think you should hear these kind of cases, even though I think, the law probably lets you. That's why we're here. If you, the lawyer, can ask that question of somebody you think is leaning that way, you should stop there once they say yes. Because if they don't believe in bringing in your specific case in front of a jury, they're done. So there's some specific case law. There's the Lombardi case. It's from 1899. A lot of judges will look to it. A lot of judges won't care because it's well-settled law, but it's really old, where basically if the potential juror says certain things, they can't be rehabilitated, right? They can't be rehabilitated. And the reason they can't be rehabilitated is it doesn't matter. So imagine this. Imagine you, the plaintiff's lawyer or the defense lawyer, asking somebody, says, Mr. Smith, now you told us that you're an insurance adjuster, correct? Yes. And you've been doing this for 20 years, right? Yes. And at the end of the day, you heard it in the joint statement of the case, and then you open. This is a car accident case, right? Yeah. And you heard that this is the kind of case where you're going to have to evaluate. You're going to have to look at medical bills, right? Yeah. And you're going to have to see, does it make any sense, right? Yeah. And you heard that there's going to be doctors coming to the stand on both sides talking about it, right? Yeah. Let me ask you, in your 20 years working as an insurance adjuster for Farmers, for Geico, for whatever, did you ever look at medical bills? Well, of course. Well, tell me a little bit about that. And that's where you want the person to open up, right? You don't want it just yes, no, yes, no. The other person, yeah, I did this for 20 years at Farmers. I worked on litigation cases, pre-litigation cases. I recommended this, that, and everything else to the, I heard from our in-house attorneys, from our outside attorneys, and you're never going to get the perfect statement. But what you want is the person basically say, I know something about how this works, right? And your client starts behind. If it's like a race, right? It's serious. It's not a game. But if it's a race, your client starts behind. Their starting block is a little bit behind the defendant. The way you could do that is basically you would say that your experience is pretty detailed and broad in the field of personal injury claim adjusting, correct? Well, yeah. Tell me more about that. And for 20 years, you relied on farmers to pay your paycheck, right? Your bread and butter was adjusting personal injury claims, right? Yeah. And it would help if you would get them to say something like, if this case were to go to trial, and if you were to sit on the jury, do you think that if you were the plaintiff, you would want a person like you being on this jury panel? Or would you want somebody else? And if you can get them to basically say, I don't think that if I was rear-ended, I would want somebody with my experience, with my training, with my background to sit on the jury, that's a really, really good sign, right? So that's a good way to do it. The idea is you're not going to get as many for cost challenges as you can, but if you can if you can get your 4 cost challenges, they're better than going through peremptory because you only got 6 of those. So remember, as a plaintiff, you got to get 9 out of 12, right? A vote of 9 out of 12. So 9-3 vote on every question on the verdict form. So you want to save your peremptories for as many as you want. And one more thing, when you're doing jury selection, if you want to be able to appeal the issue of jury selection, anything on jury selection, you have to use all 6 of your peremptories. If you take anything from this video, the most important thing you should take is do not be afraid to ask tough questions with the jury, and do not be afraid to get the jurors talking. The attorney should do less talking, the jury should do more talking. Don't give a speech, don't thank them for 2 or 3 minutes. You only have a certain period of time. And remember, there are no refunds on time in life. So if it's a smaller case, you're okay keeping it brief, maybe an hour, 45 minutes. Get as many people to talk as possible and explore as many themes as you believe are a problem to your case that you highlighted in the opening statement. Good luck in your next jury trial.